time.
Stop sharing.
Ed, are you there?
There is.
I am.
Are you locked and loaded,
Can I
ready
stop
to go?
sharing?
Yeah, I'm ready.
The little button on the left share screen right by your microphone, you just click on that thing and you'll have I think I can override you. Maybe.
There you go.
Do you need the screen, Ed?
There.
Yeah, I do.
Go ahead. It's all you.
All
Give it a
right.
shot. I hope you don't have as much problem as John earlier in sharing the screen. He didn't have the amount of participants either. Thank you very much, Smoking Baby. That was pretty cool. I'm going to call you back. I will tell you, Ed, just whatever it's worth, and listening audience, I lost a house to property taxes in 2007 in property, and he's the only man so far in the 16 years after that gave me some hope that there might be something I can do. So I'm a listening man and a learning man. I know what I know, and I don't know what I don't know, and I appreciated what I heard, and I will follow through. And only problem is he said it when I didn't have a recording nearby, which is something I really dislike. I was just confirming our phone call, and I didn't have a recording, so he spoke it so fast I didn't catch it. We're going to definitely want to have you back and share with the House of Prayer group. I appreciate your sharing. Ed, you're on.
Sean has a lot of friends over here too, and I'm sorry about the death. I will miss Hollywood as well. Holly was a great inspiration. In deference to our host tonight, I want to start out with Ephesians 4:29. Let no corrupting talk come out of your mouths, but only such as is good for building up, as fits the occasion, that it may give grace to those who hear. So I heard a lot of interesting things already. I heard Derek talk. I heard Leo talk, which he's new to me, but he's walking down a similar path that I am right now. So I've got a lot of things that I could share tonight, but I'm going to stick with one because I really believe that 2024 is going to be our year. We don't hang out at 11 o'clock at night in Georgia on these channels just to whistle Dixie. I mean, we have to understand where we're at. Okay, we have to know our status and standing, and that's why I love listening to Derek, because he's got that down to a science. When I was 28, I got a speeding ticket for 71 and a 55. I went to court. I kept the Georgia State Trooper on the stand for an hour and 45 minutes. And at the end, who couldn't answer a single question that I asked him. And at the end, I was found guilty because I never said how fast I was going. So I realized right then and there, I apologized to the court actually when the judge pronounced his sentence, and I said, "I'm sorry, I thought I was innocent until proven guilty, but apparently it doesn't work that way down here in this county." And I just walked out. I paid the $60, but I tell you what, it's the best $60 I ever spent, and that's what got me to you guys here tonight. So what I'm going to talk about tonight, and Daniel, I want to ask a favor. If I get to the 5-minute mark, stop me. If I've got 5 minutes left, stop me, because I've got something that I need to show everybody before.
I'll jump on you. No problem.
Okay. So it used to be the District of Columbia used to be the 10-mile square. It's now the 8-mile square because they had to give Virginia back 2 of the miles. So we're going to talk about being located inside the district or outside the district. And you can't find that many places that are located outside the district. But basically what I'm going to show you tonight is I'm going to prove to you that the state that you're living in right now, I'm in Georgia, so I'm going to use Georgia as the example. But the state you're living in right now is not a state. It's a federal enclave. The district expands, and I want to give another shout out to GlennWinningham, because I think I saw him on here tonight. When I really started getting into this, I got on Glenn's channel and his YouTube channel, Sovereign Living, I believe was the name of the channel. And I used to watch his videos relentlessly. And through watching his videos, I learned that the district expands to wherever its citizens roam. But now I'm seeing it in a different light. And I'm going to show you exactly why I see it the way that I do. So the first thing, and I don't know if I keep the same screen on, but I bring this over. Can you see the proof of the corporate United States right there? Or are you still looking at the jurisdiction 8 miles square?
I'm looking at the jurisdiction 8 mile squares.
Okay. All right.
Ed, I've been trying to tell people all night long, you click on the first one on the left. There you go.
Okay. All right. So after listening to Glenn's videos and doing my own due diligence and studying, I started looking at this 28 USC Code Section 3002. And I got 3 choices of what the United States means here. There's also a Supreme Court case called Hooven versus Allison, but I don't need it because I'm going to show you right now why you live in a federal enclave. So the United States means a federal corporation. It means an agency, department, commission, board, or other entity of the United States. And this word after B, or, is what threw me off. Or C, an instrumentality of the United States. Actually, for the United States to rob us all, it has to be all 3. And that's what I'm going to prove tonight. It's all 3 of these. It's not 1, it's not 2, it's all 3. So what it's saying is it's always a federal corporation. And it could be an agency, or it could be an instrumentality, a department, commission, board, or whatever else. But when you look at this, when you see the word an instrumentality, that means a municipal corporation. That's what it means, a municipal corporation, and that's what I'm going to prove to you. So I'm going to drop this. I'm going to save that. I'm going to drop that off. All right, I'm going to come back and show you. Let's just start with the beginning. So, and I hate to admit this, but I was born in February, and I was born on February the 21st. But February the 21st, 1871, otherwise known as the Reorganization Act, the District of Columbia constituted a body corporate for municipal purposes. So, okay, so I'm thinking about this, and I'm looking at the law, and I'm trying to work this out, but I just want you to know where the district came. So 1787 was the Organic Constitution, 1791 was the Bill of Rights, and 1871 was the district. And so I started looking in my own state. Well, before I get there, I want to talk one more thing about courts. So this is what I've come to learn. An agreement in law is a contract. An agreement in court is a binding contract. And that agreement, because of the Administrative Procedures Act and the Uniform Commercial Code, that agreement can be implied or expressed. And that's from the Administrative Procedures Act, and also a case called Erie Railroad versus Tompkins back in 1938. So I found this 1896 case. To make a valid contract, it is necessary to show that both parties are competent to enter into the proposed stipulations. So I heard Sean just talk about that, proposed stipulations. It is a fundamental principle in the law of contracts that to make a valid agreement, there must be a meeting of minds. And obviously, if there be a disability on the part of either party to enter into a proposed contract, there can be no valid agreement. A contract beyond the corporate power of either party is as invalid as if beyond the corporate powers of both. Now, if you ask me which one of these sentences don't fit, it would be that one right there. But then again, this was after 1871. It's 1896. So I also find this interesting here. Yes?
I think this is necessary. I don't like to interrupt, but this is something that has come up over the years, and that's the use of authority. Generally speaking, authority that's based on lawful money is not applicable in today's realm. And this was prior to 33. Lawful money was in effect in 1896. So when you distinguish authority, you have to keep that in mind. Now, don't get me wrong, there is some authority from that time period that applies. But when you're talking about contracts and consideration, that was under lawful money. So
it was under lawful money, but in what location? All right, so you got time, space, place, and plane. So the question is, even though they had lawful money back in 1896, was I using that lawful money inside the district or outside the district?
So I'm going to ask my other guest speakers, because of our time restraints, put your, if you wouldn't mind, Private, put it your statements in the chat for everybody, so Ed can proceed without interruption. I can't say enough. We've only 25 minutes.
Gotcha. I think I'll get to the point he was trying to make here in just a minute. If you'll just give me just a minute, I'll get to where you're going.
Just want to do a little moderating here, Ed.
Okay, we're all good. All good? Okay.
No.
So I started looking at official opinions. I'm going to start with one from 2009, and then I'm going to go back to 1959. But anyway, this is what it says. It has well been settled that local governments exercise only the powers delegated to them by the state, and that an attempt by a local governing authority, county or municipality, to exercise an undelegated power against the state is ultra vires. So I started thinking, well, where did the municipal corporation, where does it fit into the political subdivision, which is a county? So I got over here to 1959, opinions of the Attorney General, who was Eugene Cook at the time. He was the Attorney General in Georgia from 1945 to 1964, I think. He was there for a long time. You can't see that. Or yeah, you can see this, right? Eugene Cook, Attorney General. You see his face? Okay. All right, good. So 1959, I pulled out certain portions of the official opinions and the unofficial opinions that he wrote. So this is where it starts. The Attorney General receives numerous inquiries from county and local officials and from various public and private organizations, both within and without the state. So obviously I've highlighted private organizations for a reason, and I will get to that. Here's an opinion in 1958 that looks like they're trying to tell you what due process is. You have the right to a hearing, and you have the notice and a hearing. The word administrative is what he used in this unofficial opinion. So now we're going to go to the official opinion. Municipalities are not political subdivisions of the state of Georgia, as are counties, congressional districts, and militia districts. So I'm looking at this, and I want to tell you before I get into this, that this official opinion from the Attorney General Eugene Cook was later withdrawn. I can't find when it was withdrawn, and I can't find who withdrew it. But what's interesting is the timeline. This was in 1959. In 1963, the Georgia legislature went outside of itself and brought the Uniform Commercial Code back into the state. What's funny is the Uniform Commercial Code didn't make federal law until 1965, and it turns out if you study the Uniform Commercial Code and you go back to 7 years prior to that, Pennsylvania already was using the Uniform Commercial Code in the state. So did it start in the state? Did it start at the federal level? 8 Mile Square. What Glenn taught me, it had to already be there. So anyway, I'm showing you this. Municipalities are not political subdivisions of the state. And later on here, he tells us why. The definition, of course, would not include municipalities. They're talking about political subdivisions. Since it is obvious that the aggregate area of all municipalities in this state falls short of covering the entire geographical area. A city partakes more in the nature of a corporation to which has been delegated some governmental power. So that tells me right there that the municipal buildings, the courthouse, the parks, any government buildings, that was where the municipal corporation was located. It was just that. Because he's telling me right here that it falls short of covering the entire geographical area. As far as contracting with municipalities is concerned, the Attorney General then said that the Constitution of the state in Section 2-5901 authorizes the state institutions, any city, town, or municipality of this state may contract for any period not exceeding 50 years. And that really doesn't matter. Since I feel the municipality is not one of the political subdivisions referred to in that section, okay, all contracts with the exception of contracts with counties to be performed in convinced labor or convice labor, which I think it means convict labor, or county forces shall be let by public bid with not less than 3 bidders on any given contract participating in the bids. Again, this is the official opinion back in 1959. Municipal liability should attach only for neglect to perform ministerial duties. The construction, it is pointed out in Brandon versus Brunswick, is consistent with the common law theory of non-liability in cases involving sovereign governmental functions. It is a governmental function. So, all right, a little bit more. Governmental functions. The trend in traffic safety legislation, however, is to require those who exercise the right to operate motor vehicles over our streets, and this is what John talked about earlier, and highways to ensure the safety of those whose lives and property are in danger, considered in this connection the Motor Vehicle Safety Responsibility Act of 1951. Consider also the statute enacted in 1955 authorizing municipal corporations, counties, and other political subdivisions. So I know from reading this Attorney General opinion that the municipal corporation in a political subdivision is not a part of the political subdivision, which means that it's something else. So then I found this one. Mayor has no right to try cases involving state offenses. Again, this is municipal corporations. They had no right back in September 10th of 1955 to try cases involving state offenses. In other words, they can't charge you with state codes in like a municipal court. This was not withdrawn. It's still on the record. So I don't really understand why they would take one but not the other. But now I understand it. Now I understand. I'm going to show it to you. The judicial powers of this state shall be vested in a Supreme Court, the Court of Appeals, Superior Courts, Courts of Ordinary, Justice of the Peace, Notaries Publics, and who are ex officio justices of the peace, and such other courts as may have been or may be established by law. Well, what do we get? We got municipal courts. I found out day before yesterday that the superior courts of the state of California, which is really off the rails already, it has been for a long time, the municipal courts were combined with the superior courts. There was a Prop 220 back in 1997, and apparently 53% of the people voted to combine the municipal courts with the judicial courts. Now, anybody that understands how law works, when you combine a corporation with the judiciary, you got a real problem. You got a constitutional problem. The General Assembly shall have the power to make all laws consistent with this Constitution and not repugnant to the Constitution of the United States, which they shall deem necessary and proper for the welfare of the state. I don't know that I need to, and this power cannot be delegated, is likewise settled beyond doubt. The trial of a state case is a function of the state, and that municipal corporation have no right to inflict punishment for violations of the criminal laws of the state. So that's pretty cut and dried, right? Therefore, under the factual situation outlined in your letter, I must advise you that the answer is in the negative. So municipal corporations cannot try you for a crime, but back in 1959, it was just the government buildings. Today, the political subdivision sits inside the municipal corporation. And I'm talking about every county. There's 159 counties in Georgia. I'm talking about every county in every state. In other words, is there such a thing as a county other than the boundary lines? Is there such a thing as a political subdivision of a state? If it's all sitting inside a municipal corporation, and we all know that we're facing quasi-contracts in quasi-judicial tribunals, it's starting to appear to me like they just don't really care. So I've got other things that I could talk about municipal corporations here. I want to make sure I don't miss anything. Personal liability of municipal officers. Members of the council and other officers of a municipal corporation shall be personally liable to one who sustains special damages as the result of any official act of such officers if done oppressively, maliciously, corruptly, and that last part is huge right there, or without authority of law. I think that's pretty much it. Municipal corporations.
5 minute mark.
There were no state funds involved. Okay, so yeah, this is important right here.
5 minute mark, Ed.
I'm sorry?
5 minute mark.
Oh, God, doggone it, man. Doggone it. Okay.
How much more you got? Because we lost a little time in the beginning too, so we can go another. We can go over 5 minutes because we went over. So if you need it.
Okay. Well, I'll make it as fast as I can. Let me show you what the code looks like. So let me close the screen and open the screen back up. This is what the code of the state of Georgia looks like. The state or any of it. So everybody knows that statutes and codes are not the same type of law, right? They're not the same law. The codes are based off the statutes and they're supposed to conform with the Constitution. But anybody that studied codes for any length of time, any time at all, really knows that they're not in line with the Constitution. The state or any of its departments or agencies defined, and this is where we start making a separation. As used in this article, the term the state or any of its departments or agencies includes any department, agency, bureau, or commission of the state government, but does not include state authorities or any county or municipal department, agency, bureau, commission, or authority. Okay, so I want to show you that. So then I've got this from the Attorney General. I got to change this again. Opinions of the Attorney General. Opinions issued to the governor and the heads of the executive departments are classified as official opinions. Those issued to other state officers, such as legislators, judges, or district attorneys, are classified as unofficial opinions. Now, everything I've showed you so far were official opinions. One thing I did forget, I don't have these in order. I'm sorry, but I think you'll be able to follow me. On March the 14th, 1861, 11 states walked out of Congress. Our Republican form of constitutional government went vacant, and so did the Constitution for that applied for. In other words, the Constitution for the United States that applied to it ceased to exist. Now it's of the United States. So I got states or federal corporations. Y'all understand that. Okay, so then I'm going to come here and I'm going to nope, don't want to do that. Stop screen. Share screen. Okay, this is Pollard versus Hagan. And actually, you know what? Let me do this. This will be quicker. Let me do this. So, yeah. So if you look in the U.S. code, how this all lines up, this is 4 USC section 72, public offices at the seat of government. And this is pretty plain right here. You can also find it in UCC 9307H. It says, and I quote, the United States is located in the District of Columbia, which is pretty cut and dry. What this is saying is all officials attached to the seat of government shall be exercised in the District of Columbia. and not elsewhere except as otherwise expressly provided by law. And when I was listening to Leo, he made me think of this. I mean, he's actually using the public law. He's not using codes or statutes, which are public policy. So I've had friends in the past, and I'm sure all of you have too, that have been locked up because they violated some code. They violated a code, but what they didn't tell you was that the code is public policy. It's not public law. So we're beholden to the public law, but we're not beholden to public policy. Public policy actually defined means the government's will for the benefit of the people. So when they call you in on a code violation into court, no matter what the venue is, which is going to be a commercial, you can bank on that. But no matter what they call you into court for, they call you in under a code. This is why there's case law out there that says that the judges are merely acting in a ministerial duty. Another way to say that is administrative.
You actually have 5 minutes here, Ed. This is the actual 5-minute mark.
Okay. All right. So I want to go to what Leo said. I want everybody to understand, because this is going to drop off of what he was talking about earlier. So there's some doctrines in law. So the 1787, and I'm going to tell you how I'm winning my cases right now. So I went and got the U.S. archivist to certify me a copy of the 1787 Constitution with the red ribbons and the gold foil and their signature on it. And I got a 1791 Bill of Rights, which I called the primary contract. The 1787 Constitution, what differs from it, it's only the first 10 amendments. It was actually 12, but they took two of them off. So it's the first 10 amendments. There is no, in other words, there is no 11th Amendment. There is no 14th Amendment. There's none of that. So there's two doctrines that apply to that primary contract. Lex loci delecti. The Lex Loci, actually, I'm not going to read through this. I'll put them in the chat so you guys can look at them later. But essentially, where the contract was formed, the primary contract was formed, the question is, would the district apply to where that contract was formed? And the short answer is no. The district didn't appear till 1871. So that brings me to the next one. Oh, you know what? I just realized y'all can't see this. So let me share screen. All right, there's Lex Loci delecti. Then I'm going to bring another one over called Lex Loci contractus, or actually it's Lex Loci contractus. And what this says is that this is another doctrine. And what it says is whatever the governing law was at the time the contract was formed, no matter how long that contract lasts, it has to be governed under the same law. And there's a case from 1820 that I haven't found yet. I'm still looking for it, that says that the Constitution is deemed to be written into every contract. Okay? So that means that every subsequent contract after the primary contract is deemed to have the primary contract written into it. And therefore, none of the stuff that they're doing is it's for lack of a better word, it's a scam. They just need to make you believe it, and it appears like they're trying to make you believe it by force. So all of a sudden, okay, here we go. So I'm going to change screens again, and this is what I want to show everybody before I close it out. And I will put this research into the chat later. I will put it in. I want everybody to see this because I just learned about it the other day. Can you see my screen?
Yeah.
Okay. Can you see that? Office of Law Review Counsel?
Yep.
All right. Here's the link. And I'll put it in the chat. Actually, I'm going to put this in the chat too, but this is what I learned. The U.S. Office of Law Revision Counsel, otherwise known as U.S. Code Revisers, for some time now, and I don't know how long, have been mixing non-positive law titles with positive law titles. And so this is my heading here. This is an unconstitutional act causing public hazard and a true conflict of laws. True conflict of laws, just so everybody knows, I'll give you some examples. UCC 1103, it talks about the supplemental rules that all contracts are governed under, and the law of motion is located in B of that section, UCC 1103. Private international law is deemed a conflict of laws. Okay, even if it was by treaty, they're putting it in the codes, and they've been doing this for a long time. Those of you that I work with families out of the family law know that all of family law is based on private international law under a Hague Treaty, under a Hague Convention. So basically, think about this. If they're mixing positive and non-positive titles, they could change the whole scope and definition of what the positive titles are saying. They could change that. And why in the world would you mix positive law with non-positive law? I mean, I couldn't believe this. I had to look at it 3 or 4 times. And the thing I want to tell you about this is when you guys go to this link here at the bottom of the page, where you go, you'll see on the left side, you'll see it says change notice or change notice. And I don't know how long it's been there. But the reason I'm telling you is you can, if you go all the way down to the bottom of the page, you can disagree with this practice. And I hope that you all do that. So I'm going to bring this over here. I'm going to pull this down, and I am going to send you guys to this screen. Okay, Pollard versus Hagen. This is the end right here. This is the end of what I want to show you now that you know about the code revisers. Pollard versus Hagen was an 1845 case, and this seemed to have been a problem back when they made Alabama a state. Let me just find the head notes. Right here it is, right here. Right of soil. No. Okay. Right of soil. Okay, here we go right here. This is it. The United States never held any municipal sovereignty, jurisdiction, or right of soil in and to the territory of which Alabama or any of the new states were formed, except for temporary purposes and to execute the trusts created by the acts of Virginia and Georgia legislatures and the deeds of cession executed by them to the United States and the trust created by Treaty of 30th April 1803, which incidentally was right after the first Immigration and Naturalization Act. Actually, the second one. There was one in 1795. They replaced it with 1802, with the French Republic ceding Louisiana. But this 1845 case is telling me that there is no municipal sovereignty. Okay, and so the last thing, I got one more thing I want to show you.
We've run out of time there, Ed. So
right, this is where I'm going to prove it. This is where I'm going to prove it. Everybody wants to see this. I just got to know.
This is my chairman of the board here, banging my gavel. Your time is up. Your time is up.
All right. All right. Well, I'll leave it at there. Read Pollard versus Hagen.
Show your spot, and then let's get to the next caller, Ed. We're going to have you back on the House of Prayer call. You're a regular anyway. We love your.
Well, I just want you guys to know that what they're doing. I mean, you're not in a state. You're not in a state. You're in a federal enclave. So here we go. Stop sharing. Well, okay. Start sharing. Sorry, hit the wrong thing. Municipal corporation. Here we go. Share screen. Okay. So this is Pollard versus Hagen. This is what it says. The United States never held any municipal sovereignty, jurisdiction, or right of soil in Alabama or any of the new states which were formed. If that's true, why do we have municipal corporations encompassing our political subdivisions? And with that, I'll yield.
You, Ed. By the way, February 8th, we're having another House of Prayer call. If you want to flesh that out a little more, that goes for all of our callers that got cut off short. We're going to have another call on the 8th of February. I should announce that in the very beginning, but it's on the recording, and I'll put it in the group.